In this section, we discuss civil litigation procedure. Okay, we'll begin by describing what is civil litigation. Well, generally, it's the method by which individuals enforce their legal rights against other individuals within the judicial system. That is, they bring a legal action to remedy some harm suffered against another individual. Okay, we'll talk about the parties to civil litigation, that is a plaintiff and a defendant, and any third-party defendants that arise in that process. We'll talk about a concept called standing, or the requirement that an individual have suffered some kind of personal harm in order for them to be able to bring a legal action against someone else. That is, they must have standing. And then we'll talk about a unique type of action in which the parties are broader than those who actually appear in court. That is, a representative plaintiff or group of plaintiffs will represent an entire class of plaintiffs in bringing a civil action against a named individual or group of defendants. And we'll talk about the requirements to certify a class or a representative plaintiff to bring a class action on behalf of a group of individuals who are wronged. Okay, to start with, in the civil litigation process, we talk about the concept of personal jurisdiction. That is, the ability of the court to call an individual into court and subject that individual to their authority. Okay, there are constitutional protections in place that require the court to establish authority to call that individual into their court and subject them to their judicial process. So that normally happens through a process called service of process, or service of a summons, generally accompanied by the complaint, but service of a summons, summonsing an individual to appear before the court. Now, generally this takes place within the state's jurisdiction, but when it happens outside of a state's jurisdiction, that is, you serve the summons on someone in another state, the court must do so pursuant to something known as a long-arm statute. A long-arm statute allows the court to reach outside of the state and serve a summons on someone. Now, these long-arm statutes must be narrowly tailored in order to be constitutional. Most particularly, they can only allow for the exercise of personal jurisdiction in situations where a defendant has a minimum level of contacts or minimum contacts with the state in which the court sits. So the court will have to demonstrate that these minimum contacts exist so that it does not offend the notions of fair play and substantial justice in bringing the individual into that state to be subject to that court's procedure and process. Okay, now once the trial process begins, that is, an individual has been served with the summons and complaint, this is known as the pleadings stage. That is, the plaintiff brings a complaint and serves that complaint against the defendant. The defendant has to answer that complaint. Okay, so what happens if the defendant does not answer the complaint? So we go over the concept of what's called a default judgment. That is, an individual defaults or fails to answer, and a judgment is rendered against him or her. We talk about what it takes to ask a court to do something, and we'll talk about some common motions, as they call it, moving the court to do something, and we'll talk about particular ones applicable to the pre-trial process, pre-trial stage of the judicial process. Okay, then we'll talk about the discovery process. Discovery means the process by which the plaintiff and the defendant find out or uncover information about the conflict or dispute. Okay, we'll talk about the methods or procedures used to undertake discovery, and the scope, the type of evidence that a plaintiff or defendant can access from the other party or from third parties pursuant to the court's granted authority. And then we'll talk about the prohibitions against filing frivolous cases and the reality or practice behind that notion. Okay. After that, we'll talk about the trial procedure, or the process that takes place once the parties arrive at trial. We'll talk about the process for selecting a jury if the defendant so selects or to have a jury in this situation. We'll talk about the presentation of evidence and that step-by-step procedure as to how that takes place generally. We'll talk about the burden of proof that each party must demonstrate, that the plaintiff must show to hold the defendant liable, or that the defendant must meet in order to put forward affirmative defenses to allegations. We'll talk about the jury's verdict or their decision at the end of the trial, and the translation of that verdict into a judgment of the court. Lastly, we'll talk about, following the judgment or verdict stage of the trial, the appeal process and how that takes place. And then once the appeal rights are exhausted, we'll talk about the concept of res judicata, which is very similar to double jeopardy in the criminal context, or somewhat similar in that way that you cannot be sued for the same conduct again a second time in the same court. Then we'll talk about the process for enforcing one's judgment. That is, how do you get paid or recuperate from the defendant the amount of the judgment, or pursuant to the terms of the judgment. And then we'll talk about the concept of joint and several liability. That is, holding multiple defendants equally or totally liable for the collective liability of the parties. So collectively, this is the civil litigation process, from the pretrial process all the way to the process following the commencement of the trial and beginning of the appeal or execution of judgment process.